Hello guys, welcome to our channel Random Dictation. Subscribe our channel for more dictations on daily basis.
Be ready. Start. In the instant case, the court finds that the workers had filed an application for production of the attendance and payment register stop. This was the best piece of evidence which would prove the actual number of days which the workman had put in each crushing season stop. This evidence could not be produced by the workers since these registers were maintained by the employer's stock. The workers had filed an application for production of these records, which was conveniently opposed by the employers on the ground that the records have become very old and are not in a position to produce these records, apart from the fact that the employers also alleged that the production of records are irrelevant to the issue involved in the proceedings. Stop para. No doubt records relating to 20 years were asked, but the record of preceding 3 years from the date of the alleged termination were also summoned, which ought to have been produced by the employers, but the same was not done. Stop. If the relevant records are not produced, an adverse inference can easily be drawn. Stop. The court finds that the witness of the employers admitted that the workers were working for more than 10 years. Stop. The witness is, however, silent as to how many days these workers were working in a crushing season, but admitted that these workers were paid the wages of an unskilled workman. Stop. The witness, in all probability, was contending that wages of a substitute or temporary workman was being paid. Stop. The witness admitted that attendance was taken in Form 12. Stop. The court is of the opinion that the initial burden of the employers to prove their case was not discharged. Stop. The employers contended that these workers were working as substitute or temporary, and in order to prove this fact, the employers were required to produce their own register to show the number of days which they had worked and the payment made to them. Stop. By not producing the evidence, the petitioners did not discharge their initial burden, and when the onus shifted upon them, it became more relevant for the petitioners to discharge their burden, which they have miserably failed by non-production of the relevant documents. Stop. This leads to an irresistible conclusion that the workers were working since long. Stop para. The workers have filed a chart which has been signed by the general manager and was filed by the employers before the deputy labor commissioner during the conciliation proceedings, indicating that the working chart of the workers of the last 10 years preceding the date of their termination. Stop. Unfortunately, the labor court has not discussed anything on this vital piece of evidence, nor has the chart being produced by either of the parties before this court, and therefore this court is not in a position to judge as to whether the workers had worked for more than the second half of the crushing season or had worked from the start of the crushing season till the end of the crushing season. Stop.
The next dictation starts after 5 seconds.
Be ready. Start. The petitioner has specifically stated on oath in paragraph 15 of the writ petition that he had no knowledge of the said FIR or pendency of any criminal case against him. Stop. Further, in para 17 of the writ petition, it has been stated that the petitioner was never arrested in the aforesaid case and he never applied for bail. Stop. The learned counsel for the petitioner has even argued to the extent that the petitioner was never present in the trial and it was on the behest of other persons named in the FIR that the case was contested in the trial court. Stop. As such, when the FIR was not lodged originally, he had no way of knowing about it unless it was investigated. Stop. He was never detained at the police station, never summoned for questioning or arrested for interrogation. There was no way the petitioner could have known about the pendency of a criminal case. Stop. The counsel for the petitioner has further argued that even otherwise the said criminal case has arisen out of a cricket game being played casually in the locality. Stop. A dispute has arisen on the spur of the moment, and it was a normal kind of scuffle which cannot be any indication about the character of a person being of criminal nature. Stop. After the game was over, the matter had been forgotten by everyone, including the petitioner, and he never imagined that an FIR will be lodged in such a small matter. Stop. In any case, there is no evidence on record to prove that he had knowledge about a criminal case being pending against him, and the information provided by him in the affidavit was absolutely true to the best of his knowledge and belief. Stop para. The learned standing counsel has filed a counter affidavit and has argued that since the information given in the affidavit was belied in the verification, hence the superintendent of police was justified in cancelling the examination. Stop. On careful examination of the counter affidavit, this court could not find any specific averments or material to prove that the petitioner had knowledge of the pendency of the criminal case against him. Stop. A rejoinder affidavit has also been filed reiterating the allegation and stating therein that there was no material before the superintendent of police, that the affidavit was deliberately filed in order to conceal some material fact or to mislead the authorities into getting extra marks for the purpose. Stop. This being the case, this court comes to the conclusion that on the date when the affidavit was filed, the petitioner was not knowing that the FIR was lodged against him. Stop. Moreover, on the date when the petitioner was sent for training, he already stood exonerated by the trial court on merits. Stop. The order of the trial court has been annexed by the learned counsel for the petitioner, and the operative operation of the order clearly exonerate the petitioner, including others, of the charges under which the trial has commenced. Stop.